why this was done away with. Now, Waqf means the permanent dedication, now amended, green is amended. Any person showing or demonstrating that he is practicing Islam for at least 5 years of any movable or immovable property, having ownership of such property, and that there is no contrivance involved in the dedication of such property. Well, three things. A, he has to be Muslim. B, he has to be a Muslim practicing Islam for 5 years. And three, most important, he can create a waqf of the property he owns. He cannot create waqf on somebody else's property. This is to, my lord, eradicate the menace of encroachment of private or government property. Now, please see, my lord, this has a saving clause. I'll come to, my lord, justification on each of them. Please see the last. My lord, one more thing which we have added. My lord, just, my lord, a good thing, positive thing, my lord. Earlier, my lord, there is a concept of waqf al-aulad. Waqf al-aulad means that it's dedication of property to Allah, but for the benefit of my children. The children initially, till this amendment came, did not include daughters, widows, etc. This is introduced for the first time, not under challenge, fortunately. Now, please see, my lord, proviso. Provided that existing waqf by user properties registered on or before the commencement of the Waqf Amendment Act 25 as waqf by user will remain as waqf properties. My lord, kindly pause here for a minute. This is a prospectively applicable provision. If you have registered yourself as waqf by user, then it is saved. With two exceptions. Except that the property wholly or in part is in dispute. Lord, kindly pause here for a minute. I have not clarified in the affidavit that dispute would mean a private party may have a dispute with the property of the waqf. Lord, I as a private individual, a citizen, may have filed a suit that this is my property which somebody has declared as a waqf. That would be governed by the judicial adjudication, what the court will ultimately adjudicate upon. Lord, I don't think there can be any objection to this. If there is a dispute between private parties and a waqf with regard to the waqf property, it would not be a waqf because it would be governed by the adjudication of the competent court. Second, is in dispute or is a government property. Lord, kindly appreciate, my lords. Waqf, we are dealing with waqf by user. Lord, first category of waqf is I have a property, I dedicate it to the Allah for a particular reason, my lord. It can be for a mosque, it can be for school, it can be for hospital, it can be for musafir khana, it can be for yatim khana, several, because they say religious, charitable or pious purpose. Nobody has a right over the government land because the government being the owner of the land would mean the entire country is the owner of the land and the government holds the land in trust for and on behalf of each and every citizen. Number one. Number two, waqf by user. So there are judgments that the government, even in case of a waqf, that government can protect its property if it is declared to be a waqf. There is a Supreme Court judgment. I will not cite one paragraph from there. Lord, secondly, Lord, when we say waqf by user, by definition, the property belongs to someone else. You have acquired right by continuous use. I hope I'm clear, my lords. Waqf other than waqf by user, my property, I dedicate it to Allah, my lord, and it becomes a waqf. But waqf by user, by definition, means by long usage, it acquires the property, it acquires the character of a waqf, and therefore necessarily either a private property is used for a long period or a government property is used for a long period. Now, my lord, the question is how to decide whether this is a government land or not. For the time being, my lord, forget Waqf by usual. But suppose there is a building standing on the property, which, my lord, can be a government property. It can be a residential building, it can be an industrial building, it can be a temple, it can be anything. The question I'm posing to myself is, my lord, can the government not examine that whether this property belongs to the government I'm holding in trust for and on behalf of 140 crore citizens or not? Lord, that is provided for in 3C, which your lordship would...
That is what their condition is.
Yes.
That maybe an officer above the collector.
Correct, man.
Yeah. So
I'll answer that, man.
He is a government officer.
Yes.
The government deciding its own claim.
So I'll answer that. I'm conscious.
And given a finality to that.
My lord, that is where I may say, my lord, with the sense of responsibility, it was not only just misleading argument, but it was a false argument, and I'll demonstrate that. My lord, what happens, my lord, when a revenue correction process starts, revenue records are being corrected, the revenue authorities decide whether it is a government land or not. But revenue authorities decide only for the purpose of revenue records and correction of records. They cannot decide the title. I'll come to that, my lord. I'll satisfy your lordships. And it is not final. My lord, repeatedly your lordships were told that there is complete absence of access to justice. I am a judge in my own cause and my order is final. I'll demonstrate that, my lord, that to be not just misleading but false. Please come to page 12 of my written submissions where I have quoted 3C. Now this is the identification. My lord, initial bill was that the collector would decide, because on land revenue laws, your lordships are aware, every state has a land revenue law, and the collector decides whether the government is the owner of the property or it's a private property. But the objection raised by many was that collector himself is the custodian in this district for the revenue purposes, for the purpose of government property. So he will be a judge in his own cause. That was the arguments against the collector being the adjudicator, and therefore it was suggested by JPC that let somebody else be the designated officer. Please have a look, my lord. Any government property identified or declared as Waqf property before or after the commencement of this act shall not be deemed to be a Waqf property. Now, 2, this will have to be read with 2. If any question arises as to whether any such property is a government property, the state government may by notification designate an officer above the rank of the collector, hereinafter referred to as the designated officer, who shall conduct an inquiry as per law and determine whether such property is a government property or not, and submit his report to the state government. Now, please see, provided that such property shall not be treated as Waqf property till the designated officer submits his report. I'll come to, my lord, what is the intent. If your lordship wants to delete this, please delete it. It's in their interest, my lord, that this provision is made. And I'll demonstrate that.
So delete what, entire section 3C? No.
No. The proviso they were objecting to, the proviso.
But then, no, they are not only objecting to proviso, they are objecting to the entire section.
No, I said this when I read proviso, but I understand. No, they are not for entire section. 3. In case the designated officer determines the property to be a government property, he shall make necessary corrections in revenue record and submit a report in this regard to the government. The state government shall, on receipt of the report of the designated officer, direct the board, that is Waqf board, to make appropriate corrections in the record. Lord, the only consequence of the exercise undertaken by the designated officer under 3C will be that revenue record and the board record will be modified, will be corrected. Now, please come to, my lord, I will answer that question, my lord, but before I answer.
1 minute, first let the...
Yes, I'm sorry. There is a remedy. इसमें नहीं होगा.
So, but the only consequence of exercise under section 3C,
Yes.
is correction of records and nothing further.
Correction of record of revenue record and the board record. Nothing further, and this is what I have said on affidavit which is served upon them, but nobody, my lord, brought to your lordship's notice while arguing that my land is taken away. Please have a look at, my lord,
Then,
page.
what is the purpose? Then it will be only a paper entry.
It would be a paper entry if I want to establish, I means the government wants to establish its right of title, right of ownership. The government will have to file a suit for title. If-
What that?
Please have a, I'm reading my affidavit. Please have a look at page 95 of my affidavit. This, my lord, in all fairness, my lord, when affidavit is filed long back, should have been brought to your lordship's notice. Because the argument repeatedly made was that this is wholesale takeover of Waqf. First, revenue entries will be corrected and the entries in the board will be corrected so that if anyone is dealing with the trust property, he would know that as per revenue record, government is the owner and not the Waqf. Now, my lord, please come to page 95 of my counter, paragraph 152.
Para?
152, page 95 of my counter.
Yes.
Kindly keep, my lord, my counter handy. Does your lordships get, my lord? My lord Justice Masi get. It is further submitted that the function of the designated officer in this regard is limited. It is submitted that in case the officer's report states that the property is government property, the revenue record will be updated to reflect the same. It is submitted that the designated officer is not making a final determination of rights because it is an established principle that mutation in the revenue record is only evidence and but not conclusive of ownership, which should be evidence of possession. No, there is a typo. It is submitted that if the designated officer determines the property to be a government property under section 3C2, it would result in the government being reflected as the owner in the revenue record. Now, please see 153, very important. It is submitted that it would be open for the affected or aggrieved party in such case at any stage to approach the Waqf tribunal under section 83(2) of the Act. It's not final. There is no denial of access to justice. I'll come to that section, my lord.
Which paragraph you are reading?
153, my lord, page 96. Lord, I'll just read again, my lord, 153. It is submitted that it will be open for the affected or aggrieved party in such a case at any stage, even if, my lord, entry is changed, to approach the Waqf tribunal under section 83(2) of the Act. It is submitted that final determination with regard to the title would therefore be made by the Waqf tribunal or in appeal by the Honorable High Court and the Honorable Supreme Court. It is submitted that the final rights of the parties would be subject to the court's decision. It is submitted that updating of the revenue records as provided for by section 30C2 and 30C3 ensures that the record of rights is accurately maintained. Now, my lord, please see section 83. My lord, to answer the argument, now, my lord, repeated arguments that my decision under 3C, that is, or designated,
The picture that is being painted
is final.
is that once the collector conducts an inquiry,
Yes, ma'am.
the property will cease to be a work property.
Yes, ma'am.
And once the collector concludes an inquiry, the entire property will be taken away by the government.
No, my lord, it cannot be. It will have to be if we want to evict, it will have
It
to
will have to be, the eviction will have to be only in accordance
with law.
with due process of law.
Absolutely, my lord. Suppose, my lord, it's a municipal corporation's property which is encroached upon and it is found to be a municipal corporation's property. There would be statutory provisions and your lordship's judgment will come into play. If it is a government property without any title being determined, then, my lord, we will have to go for the title suit. I've said so on affidavit. But the repeated argument was that this determination under section 3C is final. There is no remedy.
No, not final, not only final, but immediately they will lose the possession.
Exactly, my lord. Now please see 83. Please see 83, my lord.
For according to you, the possession continues as it is unless the recourse in accordance with law
Obviously, my lord.
for taking possession or
Obvious.
eviction,
And
whatever.
this is what I have said in my affidavit. I was waiting for them to show this to your lordships, my lord, but now I am showing, my lord. But please come to page 83. Or section 83, my lord. Section 83.
Do you expect this in the Supreme Court?
Lord, all three, my lord, at least have come from the High Court, my lord, and we had certain, my lord, rules.
Last 6 years, I have seen even the lines in the judgment being read, which are only
Relevant to them. Selectively read.
Selectively.
Selective reading. My lord, kindly have section 83. Constitution of Tribunals.
yes.
The state government shall, by notification in the official gazette, constitute as many tribunals as it may think fit for the determination of any dispute, question, or other matter relating to a Waqf or Waqf property, eviction of a tenant, or determination of rights and obligations of the lessor and the lessee of such property under this act and define the local limits of jurisdiction. The proviso is not relevant. 2. Now kindly see, this confers the power. If 3C is passed, this is the remedy. Any mutawalli person in any mutawalli, it should be comma, it's a typo. Any mutawalli person interested in the Waqf,
So it should be any comma, mutawali comma.
any person, mutawalli person,
Sorry, again,
mutawalli
comma.
comma, person interested in a Waqf or any other person aggrieved, anyone. He need not, he may be just a beneficiary, he may be just a worshipper. Aggrieved by an order made under this act. This obviously include 3C order or rules made thereunder may make an application within the time specified in this act, or where no such time has been specified within such time as may be prescribed to the tribunal for determination of any dispute, question, or other matter relating to the Waqf. My lord, then please directly come to, my lord, 5, subsection 5. Which is this tribunal, my lord? The tribunal shall be deemed to be a civil court and shall have the same powers as may be exercised by a civil court under the Code of Civil Procedure while trying a suit or executing a decree or order. Correct, my lord? Then 6. Notwithstanding anything contained in the Code of Civil Procedure, the tribunal shall follow such procedure as may be prescribed. The decision of the tribunal shall be binding upon the parties to the application, and it shall have the force of a decree made by a civil court. Now, most important, my lord.
You also refer to subsection 4.
Yes, my lord. 4. I'm sorry, I missed. Every tribunal shall consist of 3 members, one person who is or has been a district judge, who shall be the chairman, one person who is or has been an officer equivalent in the rank of joint secretary to the state government member, one person having knowledge of Muslim law and jurisprudence member, provided that a tribunal established under this act prior to commencement of the 25 amendment shall continue to function and as such until expiry of the term of the office of the chairman and members thereof under this act. Lord, now please come to 8, subsection 8. The execution of any decision of the tribunal shall be made by the civil court to which such decision is sent for execution in accordance with the provisions of CPC. It has all powers of the civil court. Its order is treated as a decree of the civil court. It is executable by the civil court. But please see, my lord, this is what is introduced in 2025. This was not there up to today. That is subsection 9. Earlier it was, my lord, no appeal shall lie except in some cases. It was kind of a revisional jurisdiction. Now a full-fledged appeal to the High Court against this decision. Please see subsection 9.
Earlier, there was no provision for appeal.
There was a provision, my lord, which is at the bottom, but it was like a revision, call for record and examine validity, etc. Now, what is provided for is a full-fledged first appeal. My lord, please have a look at what was earlier, my lord, subsection 9. Because I cannot be selective in my reading, my lord. The government must assist fully. Your lordships would find in the book, my lord, the bottom,
Provided High Court may on it.
no appeal shall lie against any decision or order, whether interim or otherwise, given or made by the tribunal. So the first finality was given. Then, provided that a High Court may, on its own motion or on an application of the board or any person aggrieved, call for and examine the records relating to any dispute, question, or other matter which has been determined by the tribunal for the purpose of satisfying itself as to the correctness, legality, or propriety of such determination, and may confirm, reverse, or modify. It was like section 115 of CPC, akin to that, but now it is a full-fledged first appeal. And against which, my lord, depending upon, my lord, the High Court's jurisdiction, in some High Courts, if the first appeal is taken up by the learned single judge, then intra-court appeal also lies, where there is a latest patent, or my lord, SLP before your lordships. So it is absolutely wrong to say that 3C order is final. 3C order is not final. It is subject to judicial review, having layers of judicial adjudication available. Now, my lord, when your lordships are at page section 83, please read, my lord, 85 also. Yes. No, please see section 85.
Shankaran, you are on this side.
Yes, Manoj. I'm appearing for the board.
Yes,
We are in fact.
No, he is for one of the Waqf boards.
No,
My
no.
lord, everyone is not on the other side, my lord. Even in the community, my lord, I don't think they can claim.
We don't take it as a community or otherwise, but we are only deciding what the matter is before us.
Obviously,
There's a fair
my lord,
balancing.
I'm not
possible.
concerned with that.
Constitutionally, there's a fair balancing that's been
Yes.
done by the Amendment Act, is what I feel. Yes.
We'll have your assistance.
Yes.
My lord, do we reserve our arguments, my lord, on this, or will your lordship give us the right to reply?
We'll give you half an hour, but then this was,
My lord, because.
I'm reading provisions. What reply can you?
One point,
no, and it is not as if that he is arguing something new. If there is already a foundation for that argument in the counter affidavit.
Mr. may clarify, my lord, for the future, Waqf by user is abolished. 3R1. And the proviso, my learned friend says, it will not be Waqf in the meantime. He says you can delete it. Now, my lord, Waqf, our point, my lord, our point is Waqf by user is abolished.
Mr. Dhawan, we did not permit Mr. Tushar Mehta to interrupt.
My lord, I apologize. My lord, I apologize.
So he was tempted quite a few times.
No,
Because, my lord, there were certain statements which were
my lord,
peculiarly
I
incorrect.
stand admonished, my lord.
We are not
I
admitting.
apologize.
You are too senior to.
No, my lord,
We are
I
only,
apologize.
yeah, we are only reminding what we did with Mr. Mehta.
Only following his example, my
No,
lord.
we did not permit him, Mr. We don't know about the other courts, but when he was trying to compete with the anxiety of that young girl, he was not saying 2 days ago.
My lord, he is a master at all this, my lord. I'm only a novice.
So we did not permit him to be so anxious.
Lord, he is too senior, my lord, for me to respond,
Yes.
though I can. Lord, now please see 85, section 85. No suit or other legal proceedings, your lordship gets, my lord. Dispute, question, or other matter relating property or other matter which is required by or under this act to be determined by a tribunal. Now come back, my lord, to 3R, my lord, in my note. (3)(1)(r). I'm sorry, 3C. Sorry, 3C first, my lord. provided that, my lord, kindly read, my lord, page 13 of my written submissions. They say that before you even adjudicate, my Waqf is taken away. That was the argument. That is the pitch at which the argument was made. Please see, my lord, proviso, page 13, the top line. Provided that such property shall not be, please mark, treated as Waqf property. Treated, my lord. My lord, the purpose is, if you wish to file a civil suit, your character as a Waqf property is kind of in suspension so that you can take remedy. It's not that the Waqf will be snatched, but the word used was that this is en masse taking over of the Waqf.
Work
It
property.
is capture of Waqf property. Yes, my lord, I'm thankful to my learned friend. The word used was wholesale capture of the Waqf. Only thing 3C does is deciding the revenue entries and the ownership right, correction of revenue record, correction of board record, and ultimately, my lord, it will be the competent court, my lord, or the tribunal which will decide the question, my lord. Now, my lord, coming back, please come to, my lord, 3RF. Now, it is my
What
case.
what you are trying to say on the basis of proviso is that it continues to be a Waqf.
It's
But
not
it
treated
cannot-
as a Waqf. Yes, my lord. So that
Two aspects you have clarified. One, the possession continues as it is.
yes, my lord. And if we
Second
want,
aspect is that the property continues to be Waqf, but not to be treated.
not to be
as-
treated, that embargo is lifted as a character. That's all.
It is a status quo as such.
Yes, no, it's not even status quo. They can exercise whatever court they want to go, as if they are not a trust.
That in any case is.
Suppose
Otherwise,
they-
there is a,
They want to alienate the property as a work property.
then they cannot,
They can't, unless the dispute is decided by.
yes, my lord, that is the purpose, because otherwise you alienate the moment the notice is received from the designated officer.
In a way, therefore, what my learned brother says is,
Correct,
Still,
status quo is.
status quo,
Yes,
till
correct.
the rights are adjudicated by a competent forum.
Correct, correct. Because it's till it is decided whether it's a government property or not, how can that be transferred or encumbered upon? My lord, now kindly come back, my lord, to page 4, the proviso, my lord, which is under challenge. And I may answer, yes, from this amendment date, Waqf by user is not a permissible mode of creating Waqf. That's the legislative policy. Now, any Waqf can be created henceforth prospectively only by a registered Waqf deed. But past Waqf by users are saved, provided they are registered. And with an exception, if it is a private dispute, then obviously nobody can object, my lord. If it's my private property, I have filed a suit.
Dispute will also, in view of 83 and 85,
Yes,
such a dispute will also have to go to the tribunal.
it will have to be it will have to go to the tribunal, my lord. But even, my lord, there are some suits pending. There may be some suits pending. So I have specifically said in my affidavit that any such dispute with private individuals will depend upon the outcome by the competent forum, judicial forum.
So again, even according to, in your view, even according to proviso also, the possession would not be taken unless it is decided by a competent forum under 83.
And or in accordance with law. Suppose, my lord, it is decided that the property is that of a municipal corporation. Then there would be a law governing the possession. There would be a municipal corporation law or a municipality law, and thereafter your lordship's judgment will take over. Notice by registered post, this, that, and others, my lord. So not possession will not be and cannot be taken over except in accordance with law. Not by operation of 3C or the proviso to 3C. It was a deliberately misunderstood argument to create a confusion. I don't think, my lord, even they have understood it that way. It was an alarming argument that this is the major, manifestly that it is being snatched away. That was, my lord, the argument.
Wholesale,
Captured,
wholesale capturing.
wholesale capturing, my lord. But that is the reason, my lord. Why? Why, my lord, your lordships generally do not entertain a petition till the statute operates. Once the statute operates, your lordship comes to know what is the intention of the statute. And some aggrieved party will come. These are all, my lord, on academic level, we are discussing what is the meaning of this section, that section. Your lordships are aware, Kusum Ingor's judgment, that there cannot be any academic challenge without an aggrieved party before the court. But I'm answering, my lord, on merits. I'm not going on that technicality because I have an answer on merits. Now, my lord, please see, the only exception which is made is only registered Waqf by user will be protected. My lord, please come to page 12 of my counter. I'm sorry, my lord, page. No, not 12, my lord. Please come to.
No, Mehta, how much is your estimate?
My lord, I'll be by 1:15, my lords.
And who are others?
My lord, others are also there, my lord. But my lord, even if my lord, we'll conclude by today, my lord.
If something remains, we are not going to repeat anything. Don't do that. There's absolutely no way. If something remains,
You heard
To assist your lordship. Your lordship must get assistance from all quarters. my lord.
वो बोर्ड डिस्चार्ज for the day कर दो. Function वगैरह कर दो.
I want to start with वो जो, हाँ. Now, please come to, my lord, my affidavit on registration part. My lord, the argument was that registration was never mandatory. My lord, that was the first argument. Your lordships were pleased to record it. The second argument was
Because there are no consequences for non-registration.
consequences provided. Now, my lord, I have, my lord, gone to the root of the problem which British government tried to solve, Indian government tried to solve throughout. Please come to page 16. And, my lord, this is the statement of objection reasons of Musalman Waqf Act 1923. Very crucial, very important, my lord, for your lordship's assistance. My lord, 1913, my learned friend said that 1913 is the first amendment, first enactment. My lord, it was not there. Waqf al-Aulad was recognized. That's all. It was not an enactment in that sense. This is the first enactment governing regulation and administration of Waqf properties. And kindly, my lord, allow me to read the statement of objects and reasons, and your lordships would find, my lord, the answer to why 5 years. Practicing Muslim. This menace has been going on since 102 years. Please have a look at, my lord, page 16. Does your lordships get, my lord, page 16 of my counter, statement of objects and reasons. My lord, may I read? May I read? The object of the present bill is sufficiently indicated by the preamble to the bill. For several years past, there has been a growing feeling amongst Mohammedan community throughout the country that the numerous endowments which have been or are being made daily by pious and public-spirited Mohammedans are being wasted or systematically misappropriated by those into whose hands the trust may have come in the course of time. Please mark this, my lord. Instances of such misuse of trust property are unfortunately so very common that a Waqf endowment has now come to be regarded by the public as only a clever device to tie up the property in order to defeat creditors and generally to evade the law under the cloak of a plausible dedication to the Almighty. My learned friend, my lord, is entitled to recover 1 lakh.
Once, is there a provision that once a property is declared as a work property that it can't be?
Yes, it is dedicated to Allah. So, my lord, my learned friend is supposed to, my lord, recover 1 crore from me. He files a suit. If his suit is decreed, it can be, my lord, realized from my property. I declare my property as
To
Waqf.
declare it to be a work property, it can't be.
It can't be. And for that purpose, there is a possibility that I will say that I have converted myself into Islam.
Like,
Marriage,
Goa marriages.
like marriage. Therefore, I'll come to that, my lord. It's not as if that you will have to establish that you are offering 5 namaz and you are not drinking wine, etc. That's not the thing. And I can tell your lordships, Sharia Act, which governs all Muslims in their personal law, has section 3 that you have to establish that you are a Muslim. Only then Sharia Act applies. I'll come to that. But please have a look at, my lord, further. This is what, my lord, the problem the country faced in 1923. My lord, Waqf definition is, Waqf means the permanent dedication by any person. It is a permanent dedication to Almighty Allah. It's not a gift like Hindu.
So therefore, compulsory registration, according to you, is to avoid this menace.
This menace and mismanagement of Waqf properties comes further. And this is not, I have not written. This is in 1923, the British government, my lord, when this act came for the first time, my lord, please have a look at, my lord, further. In some cases, mutawallis are persons who are utterly unfit to carry on the administration of Waqf and who, by their moral delinquencies, bring discredit not merely on the endowment, but on the community itself. It is believed that the feeling is unanimous that some steps should be taken in order that incompetent and unscrupulous mutawallis may be checked in their career of waste and management, mismanagement, and that the endowments themselves may be appropriated to the purpose for which they had been originally dedicated. In some cases, please mark this, the purpose of registration. In some cases, difficulties have arisen in finding out whether any particular properties are really subject to Waqf or not. There are numerous Waqf properties all over the country, unknown to the public, which the mutawallis are treating their own property and dealing with in any way they think fit or necessary. Please see, my lord, further. It therefore seems that to some responsible officer, not merely about the fact of the Waqf of which he is the mutawalli, but also the nature and extent and other incidents of the endowment. Further, even a Waqf is well known and mutawalli is obviously thoroughly incompetent to carry on his duties, the public find a difficulty in instituting suits to remove him from his post by reason of the cumbersome procedure laid down in the Code of Civil Procedure. It is with a view to facilitate the institution of such suits that a provision has been made in the bill. Lastly, there appears to be a general consensus of opinion among Mohammedans throughout the country that there should be some responsible officer who may go about and find for himself whether various Waqf properties scattered throughout the country are being properly managed or not. Lord, the argument was that it's not our responsibility to register. It would be the survey commissioner who will survey. I will demonstrate from 1923 onwards, there are 3 tiers of responsibility. First, if I am a Waqf, it is my responsibility to get it registered. If I don't do it, there was a penalty provided. Second, with a view to ensure that unscrupulous people by...
Whether 1923 Act also had a provision for registration.
100%, I am going to show that.
Earlier, Mr. Kapil Sibal made an argument that in 1923 Act also, that there was a registration, but then subsequently he said from 1954, that is what we are recorded.
Please have a moment. I have quoted sections. I am reading from the sections.
He argued that it is for the first time that registration came in 1954.
My lord, I am reading from the sections, my lord. Yes, please have a look at, my lord, section 3. Page 70, my lord, 17, section 3. Within 6 months from the commencement of this act, my lord, kindly note one fact while reading this section, and that is very, very crucial. Look, there is a campaign going on in the country that 100 years old Waqf properties are there. From where do we get the papers? हम कागज कहां से लाएंगे? That's the narrative which is built. Argued here also. And I will show कागज कभी जरूरी नहीं थे. Because the law knew that there can be old properties where there may not be any documents available. Please have a look at section 3, my lord, in this light. How, my lord, a misleading campaign or, my lord, a kind of a narrative is being built. Obligation to furnish particulars relating to Waqf. Within 6 months from the commencement of this act, every mutawalli shall furnish to the court, not, my lord, officer, earlier it was court, within the local limits of whose jurisdiction the property of the Waqf of which is the mutawalli is situated, or to any one of the 2 or more such courts, a statement containing the following particulars, namely, no documents, my lord, the Waqf deed is not required. Please see, a description of the Waqf property is sufficient for identification. You can always say this survey number, this gully, this mohalla, etc. Description which is sufficient to identify the property. B, the gross annual income from such property. In 1923, within 6 months when you are going before the court, you will have the accounts at least. It's not that 200 years back you have to go. The account of the income of the property, the gross amount of such income which has been collected during the 5 years preceding the date on which the statement is furnished, or of the period which has elapsed since the creation of the Waqf, whichever is shorter. If you say Waqf was created 100 years, then you provide only for last 5 years. The amount of government revenue and cesses and all rents annually payable in
Maximum is 5 years. Suppose if they claim that the work is of 100 years old,
100 years,
then
then
you have to only give the accounts of 5 years.
last 5 years. It was very reasonable. And nobody said that Waqf deed is necessary. The argument was that who will have the Waqf deed? Now please see, an estimate of expenses annually incurred in the realization of the income of the Waqf property based on such details as are available of any such expenses incurred within the period of which particulars under clause C relate. Then amount set apart, my lord, for salary, etc. Please see 2. Every such statement shall be, it was not, my lord, a mere formality. There was a sanctity attached by, my lord, by the act. Every such statement shall be accompanied by a copy of the deed or instrument creating the Waqf, comma, or if no such deed or instrument has been executed or a copy thereof cannot be obtained, shall contain full particulars as far as they are known to the mutawalli of the origin, nature, and object. Look, very relevant for the user. The other side said that where do we get the document? The 1923 says document, if you have, provide, otherwise, provide whatever you know about the origin. That this person started this practice, this person started this particular premises, whatever is within your knowledge. Then third, where a Waqf is created after commencement of this act, that is after 1923, or we are not concerned, my lord, please come to thereafter. The statement referred to in subsection 1 shall be furnished in the case referred to in clause A within 6 months of the date on which the Waqf is created, or if it has been created by a written document of the date on which such document is executed. So if it is created after 1923, within 6 months, you have to go and inform about this before the court, so that there is a contemporaneous record. You can't just say that this is going on by usurer since 100 years. Now, please come to 4. My lord, what would happen when it goes before the court? Court would publish it, so that if it is my property and my property is being shown as a Waqf, I'll have a right to object that this is my personal property. It can't be a Waqf. Please have a look, my lord. Section 4, page 19. When any statement has been furnished under section 3, the court shall cause notice of the furnishing thereof to be affixed in some conspicuous place in the courthouse and to be published in such other manner, if any as may be prescribed, and thereafter any person may apply to the court by a petition in writing, accompanied by the prescribed fee for the issue of an order requiring the mutawalli to furnish further particulars and documents. I will have a right of objecting. Now, please come to, my lord, statement of accounts. Lord,
Sorry, Manoj, for not being here.
Your turn is yet to come.
Pro bono matter I have to do.
No, no.
Follow that, and therefore I apologize.
You should follow Dr. Singhvi.
No, it was only that exception, the Ashoka.
No, you don't require permission to
I
go out.
apologize. I apologize.
Lord, file. Statement of accounts were to be filed in the court every year. This was a statutory mandate. Then, my lord, 6, I'm not reading it, but my lord, your lordships can take it from me. This required a statutory audit by a chartered accountant in 1923 if your income exceeds a particular amount, and other audit, my lord, if it is less than the amount. Then, my lord, how will you file that application before the court? I'm showing the sanctity of the statute, my lord. Please come to page 21, para 8, section 8. When I file, my lord, as a mutawalli before the court, this is what I'm supposed to do. Every statement of particulars furnished under section 3 or section 4 and every statement of accounts furnished under section 5 shall be written in the language of the court which it is furnished, to which it is furnished, and shall be verified in the manner provided in the Code of Civil Procedure for signing and verification of pleadings. You can't just go and throw one letter. It has to be verified as per the CPC. This was the sanctity. And now, my lord, my learned friend said there was no consequence for non-registration. Here, registration means you go to the court and get yourself registered. It's higher than registration because it has to be before the court, and the court would finally, my lord, publish the list of Waqf, my lord, which they have received. Please see section 10. Any person who is required by or under section 3 or section 4 to furnish a statement of particulars or any document relating to so and so, please come to the last 3 lines, be punishable with fine which may extend to 500 rupees, or in case of a second or subsequent offense, with fine which may extend to 2,000 rupees. Now, my lord, most important.
Mr. Sibal may be technically right. Because he said that registration was not necessary. What was
This is more
provided,
than registration.
but what was provided was making a statement. So, technically, it may be right.
Not technically also, my lord. It is something more than, my lord, registration. You are going to the court and court is thereafter taking over. My lord, my learned friend, my lord, wants me to show, my lord, and I have missed in my affidavit, section 9. I'll just read. Your lordship did not take, my lord. It's not there. I'll just read, my lord. Section 9 of this very Act, 1923 Act. Inspection and copies. This is where registration comes. The court registers it in its register, the court's register. Any person shall, with the permission of the court and on payment of the prescribed fee at any time at which the court is open, be entitled to inspect in the prescribed manner or to obtain a copy of any statement of particulars or any document furnished to the court under section 3 or section 4 or any statement of accounts under 5, so and so, so and so.
So, in the public domain.
This remains with the court and I can get copies. It's more than registration. And, my lord, after, my lord, initially the petitioner said there is no consequence provided. Thereafter, my lord, they changed their position and they said that there is some penalty, but it is penalty
According to them, it is only for Mutawali.
for Mutawali, but the trust
Waqf does not take.
Waqf would continue. So after 1 year, another Mutawali can be punished, but the Waqf continues. After few years, another Mutawali will be punished, but the Waqf will continue. That's not, in my respectful submission, an absurd way of reading any statute. Now,
No, but in any case, it is not provided that the work will not continue or it will cease to be a work. That's not provided. As a matter of fact, in the provision.
As a matter, yes, but can you see the
Yes,
object?
the consequences are that the Mathivalli is.
And object is that every Waqf should be in public domain so that public
That is
knows about.
That section 9 says.
Yes. Now, my lord, come to, my lord, I must say, my lord, in 1923, my lord, Act, Waqf by user is not there. But that was a concept well known. To just show that even in 1923, there was a concept of Waqf by user at page 22. I have quoted, my lord, a section of Bengal Waqf Act, 1934, which defined Waqf by user. So it was not as if Waqf by user was a completely alien or an unknown concept in 1923.
1934.
Yes. But 1934, Waqf by user has to start, my lord, much before 1934. Interestingly, this act, 1934 act, was challenged before Calcutta High Court on almost similar grounds and upheld. But I'm not going into it, because we are arguing for interim relief. Whether would your lordships consider staying this provision? Now, my lord, comes 1954 act. This is the first enactment after independence.
Exception here. It will not apply.
Now comes 1954, Act of 1954, page 22 of my reply notes. Now, my lord, one more layer is added because the legislature, my lord, experienced that Waqfs are not getting themselves registered. So they are not coming within the fold of regulatory mechanism of the Waqf Act. But registration has, my lord, what is the significance of registration? I pose a question to myself. So that you are regulated by the regulatory mechanism of the Act and you do not mismanage the Act. You do not deal with third parties and cheat them, etc., etc. And if you want to transfer a property, you need somebody's permission. Your accounts are audited, your accounts are being seen by the Waqf board, etc. And the board is only a secular administrative supervisory control board. I'll come to that. Please have a look at, my lord, for the first time, this survey concept was introduced. That first, it is your responsibility to get it registered. But if you do not, then second, there is a second option, my lord. Preliminary survey of Waqf. My lord, kindly come to subsection 3.
Section 3, therefore, is the same. Section 3, which is the Waqf.
Section 3 is now definition, my lord. Now, my lord, the court part goes. Now registration is with Waqf board. For the first time in 54, Waqf board came to be created. Earlier, the administration was with the court. But maybe they may have found that court is otherwise overburdened rather than taking supervisory control over Waqf. There was a separate mechanism provided. Page 23, section 4, subsection 3. The survey commissioner shall, after making such inquiry as he may consider necessary, submit his report in respect of Waqf existing at the date of commencement of this act in the state or any part thereof to the state government, containing the following particulars, namely the number of Waqf, the nature and objects of each Waqf. So first, if you are a Waqf by user, you should have got yourself registered. Second, if you are a Waqf by user and you have chosen not to get yourself registered, you will be caught at this stage. The commissioner will catch you. Now kindly directly come to subsection 5. If during any such inquiry, any dispute arises as to whether a particular Waqf is a Shia Waqf, as your lordship can see. 6. The state government may by notification in the official gazette direct the survey commissioner to make a second or subsequent survey of work properties in the state. If the state government finds that no, there is something missing, you again do it. But now kindly come to section 5. Section 5, publication of list of works. On receipt of a report under subsection 3 of section 4, the state government shall forward a copy of the same to the board. The board shall examine the report forwarded to it under subsection 1 and publish in the official gazette a list of works in the state, or as the case may be, the part of the state, whether in existence at the commencement of this act or coming into existence thereafter, to which the report relates. Why? So that disputes can be raised. That this is my property which is declared to be a work property. This was the significance of registration. Now please see dispute regarding works. If any question arises whether a particular property specified as work property in a list of works published under subsection 2 of section 5 is a work property or not, or whether a work specified in such list is a Shia or Sunni work, the board or the mutawalli of the work or any person interested therein. If it is my property declared, then I am interested person, may institute a suit in a civil court of competent jurisdiction for decision on the question, and the decision of the civil court in respect of such matter shall be final. Now, my lord, see the explanation. Lord, kindly see subsection 4 at page 26. The list of works published under subsection 2 of section 5 shall, unless it is modified in pursuance of a decision of the civil court, be final and continue and conclusive. Then, my lord, 6A is a power of the tribunal to determine the dispute, whether it's a work property or not, my lord. Please come to 28 now. Section 25.
So there are two mechanisms, sir.
Yes, first is my duty to register.
Under the 54 Act, so a suit as well as a tribunal were both functioning.
That was a suit only, my lord. Yes, my lord. Yes, your lordship are right.
6A power of tribunal. to-
6A, yes, my lord. 6A is a power of the tribunal. Your lordships are right.
It appears they added through an amendment later.
It is added, my lord, in 1984. My lord, 84 amendment has a very interesting history I'm going to show. That was very, very relevant, my lord, to show. My lord, the section 6A itself makes it clear.
Ideally, they ought to have deleted 6.
Yes.
The provisions are almost parliamentary.
But I'll come to that. My lord, this was thereafter not implemented. I'll give the reason why.
It has to come effect from the date on which this will be notified. So that notification might not have come.
It did not come, and I'll show, my lord, why it did not come. So now come to page 28. Section 25, registration. Now, an independent duty to get yourself registered. You cannot rely upon the survey commissioner's survey. You have an independent duty to get yourself registered because there is a penalty provided. Every waqf, whether created before or after the commencement of this act, shall be registered at the office of Waqf Commissioner. Before, so even if it is 100 years old, if you have missed the 1923 route, then still you can register. Then application for registration shall be made by the mutawalli, provided that such application, please my lord, mark this, such application may be made by the Waqf or his descendants or a beneficiary of the Waqf or any Muslim belonging to the sect to which the Waqf belongs. So not just Mutawalli, the registration had this significance that anyone should come and get it registered so that it comes within the regulatory framework of this act. Now, my lord, please see 7, subsection 7. My lord, now kindly see particulars. Again, my lord, from where do we get the documents? The narrative which is built. Please see subsection 3. An application for registration of the registration shall be made in such form and manner and at such place as the Waqf Commissioner may prescribe and shall contain the following particulars so far as possible. Please see, a description of Waqf property is sufficient for identification. That's all, and the remaining is same. Accounts, this, that, audit, who are the beneficiaries, what are the salaries you are paying, not Waqf deed or any other document. Now, please see 7, my lord. On receipt of an application for registration, the Waqf Commissioner may, before registration of the Waqf, make such inquiries as he thinks fit in respect of genuineness and validity of the application and correctness of any particular. My lord, suppose I go and say that this property is being used as, my lord, kindly mark this. This is a user has to be by definition on the land not belonging to the Waqf. It has to be someone else's land. By definition, I get a right of user from somebody's land, either a private land or a government. Therefore, this requirement that application comes, you will have to inquire. And 8 is very, the window is given that though you were responsible to get it registered in 23, you have not done so till 54, please come to 8. In case of Waqf created before commencement of this act, it can be 100 years old, it can be 50 years old, whatever. Every application for registration shall be made within 3 months from such commencement, and in case of Waqfs created after such commencement, within 3 months. So a window is given that even if you have missed registration, please get it registered.
Under the 23 Act, it was 6 months, now it is 3 months.
Yes. So that even if you have missed 23, now get it registered within 6. Now please come to, my lord, section 26. There is a register of Waqf. The Waqf Commissioner shall maintain a register of Waqf which shall contain in respect of each Waqf copies of Waqf deeds when available and the following particulars, namely, A is enough, my lord, the class of the Waqf. He will have to mention that this is Waqf by user, Waqf al-Aulad, whatever. But we are concerned with Waqf by user, he has to mention this. Now, please see, my lord, the third layer was added, that if the commissioner also misses, the Waqf also does not discharge its mandatory obligation of registration, then the power was given to the board. Section 27. Please mark, my lord. The board may, your lordships are on page 31. The board may itself collect information regarding any property which it has reason to believe to be Waqf property, and if any question arises whether a particular Waqf property is a Waqf property or not, whether a Waqf is a Sunni or Shia Waqf, it may, after making such inquiry as it deems fit, decide the question. So third layer, the argument was that it was the duty of the Waqf board to decide whether I am a Waqf or not. No, your duty under section 25 to register it. Second layer, the survey commissioner independently will examine whether somebody is missing. And third layer, this. Now, Lord, please see 3. Where board has any reason to believe, that this is important, that any property of any trust or society registered in pursuance to Indian Trust Act or under the Societies Registration Act or under any other act is a Waqf property. So even if a Muslim creates a trust, what happens, Lord? The board may, notwithstanding anything contained in such act, that is Indian Trust Act, hold an inquiry in regard to such property, and if after such inquiry, the board is satisfied that such property is Waqf property, call upon the trust or the society as the case may be, either to register such property under this act as Waqf property or show cause why such property should not be registered. So even if it is a registered trust, the board will call and say that now register it as a Waqf. The choice was not there. And I'll come to that proviso to section 1. This is taken, the proviso to section 2. That now if a Muslim doesn't want to create a Waqf, but still wants to do charity, he can create a trust. It's an empowering, enabling provision. I'll come to that, my lords. Now please see, my lord, most important, 28. Power to cause registration of Waqf and to amend the register. My lord, I'm on page 32, section 28.
Yes, we have it.
Waqf commissioner may direct a mutawalli to apply for the registration of a Waqf or to supply any information regarding a Waqf, or may himself cause a Waqf to be registered, or may at any time amend the register of Waqfs. He can direct that you get it registered, or I will myself register it. And the penalty, my lord, if a mutawalli fails to apply for registration, then, my lord, please come to A, somewhere in the middle. If a mutawalli omits or fails with a view to concealing the existence of a Waqf to apply for its registration under this act, in case of Waqf created before commencement of the 1984 Act within the period specified thereof in subsection 8 of section 25, or within a period of, my lord, one window is given. Again, but the penal provision. Now, my lord, again, my lord, the government found, this is crucial, why registration is necessary, and this is not even brought to your lordship's notice by the petitioners. My lord, government found that still there is maladministration going on in the trust. Registration is not taking place, so that they are not under the statutory regulatory mechanism of the act, and properties are being dealt with the whatever manner in which the mutawalli, etc., or even the board is doing. But the central government appointed a committee in 1976.
Para 53.
Para 53, my lord. The 3 members' names, my lord, I have given, Syed Ahmad, etc. Now, please see, my lord, what was their report, which is relevant for the present purpose. The said committee was also very clear that concealment of Waqf and its willful non-registration is a serious issue. This is the reason why the proviso says only registered Waqf by users are protected, not unregistered Waqf by users. In that context, please read, my lord, the finding of this committee appointed by the central government in 1976.
76?
So 1976. This report is 1976. And something interesting, I'll come, my lord. The report was implemented. A law was passed, and the law was not given effect to, and I'll show the reason why.
Yes.
Now, my lord, this is the findings of the committee. Deliberate concealing of Waqf. My lord, this is the committee's finding. This is not my submission. Committee's findings are quoted. Deliberate concealing of Waqfs and willful failure to have them registered is a deeply prevalent malady affecting the administration of Waqf. Attaching the highest importance to this matter, we have separately provided for imprisonment in such cases as a punitive measure. We consider that a carrot and stick policy is also required in the matter, dangling the carrot wherever possible and using the stick wherever it becomes necessary. Please mark this now, my lord, and my lord, bear this in mind. We consider that in the implementation of this policy, we have a state salutary provision under section 31 of the Bombay Public Trust Act. Your lordships would recall yesterday, they said that registered, if it is not registered, my right to go to the court is taken away. Your lordships recollects that? Kindly bear that in mind and read further. Bombay Public Trust Act. All Trust Act has this provision. If you are not registered, you cannot file a suit. And the committee records that. Bombay Public Trust Act 1950 which bars the hearing of any suit in respect of a public trust which has not been registered under the Act. We consider that a similar provision is necessary in the Central Waqf Act of 1954, and no mutawalli who has failed to have Waqf registered as required under the Central Waqf Act should be provided with the facility of enforcing any right in a court of law unless he has duly registered his Waqf as required under this Act. We therefore recommend that a fresh section 55A may be added to the Central Waqf Act on the following lines. No suit to enforce a right on behalf of a Waqf which has not been registered under this Act shall be heard or decided in any court or tribunal. The provisions of subsection 1 shall apply to a claim of set-off or other proceedings to enforce a right on behalf of such Waqf. Now, this is, my lord, brought in 2025, but the history in between is interesting.
From 1976 to 25.
But in the meanwhile, the parliament amended it. It's very interesting, my lord. Please see. Based upon this recommendation, the parliament amended the Waqf Act by Waqf Amendment Act 1984, providing for the following amendment inserted in section 55E. My lord, the same, that that you cannot file a suit. Now, please come to, my lord, take the book, my lord, this Waqf Act. My lord, this was passed by Parliament. 55A is a section passed by the Parliament. It was not brought into effect. And please see the statement of objects and reasons where.
With effect from a date to be notified. So that date was not notified.
Why? We kindly have a look. Look, there were two amendments made in 84. My lord,
6A and 55E.
no, the third amendment. Third amendment was
So 6A was also sought to be brought by the.
brought by. But the third amendment was period of limitation. If it is Waqf property and I want to claim adverse possession as a Waqf, then earlier there used to be no period. It was prescribed as 30 years and 12 years for private party. Then this provision that if you are not registered, you will not file a suit. Passed by the parliament, not given effect to, my lord, please see statement of objects and reasons. The actual working, your lordship gets, my lord.
Which page?
My lord, the same, my lord.
Same book.
Same book, my lord, page 1.
Of 2005.
This is 95. Yes. Lord, it's earlier known as Waqf Act 1995. That's the title, my lord. Statement of objects and reasons. My lord, page 1, my lord, your lordships are possibly, my lord, the Chief Justice is much ahead.
25 amendment or?
No, my lord, 20, I want to show the statement of objects and reasons in 95 Act.
95.
95. My lord, Act is the same, 25, only name is changed.
This is immediately after the index.
Yeah, yes, my lord. The title would be this, my lord.
Waqf Amendment Act.
Earlier known as Waqf Act, 1995. If I can, my lord, give me another copy.
I can give your lordship.
They will have a different book.
Lord, I have a copy, my lord. I have another copy.
If you have one copy, I can give another one.
So we can share
Different. Pagination may be different. Okay. My lord, I may clarify, there are no two acts, 95 Act and 25 Act.
Right. Just see if I've seen that.
Lord, your lordships may have this, Lord, another copy, may kindly have this.
Yes, we have it. Yes. After Roman page 25, that's one there.
Page 1 at the foot of the page.
Yes.
Lord, statement of objects and reasons. Your lordship gets, my lord, in the middle, statement of objects. and
Yes, sort of 95 act.
Yes. The actual working of the Waqf Act 1954 had brought out many deficiencies in it, as also the setup of Waqf boards, especially their powers of superintendence and control over